Good afternoon and welcome. My name is Austin Parrish. I'm the Dean and James H. Rudy Professor here at Indiana University's Maurer School of Law, and I'm delighted to welcome you to the 2021 Jerome Hall Lecture. Jerome Hall was a beloved faculty member at our school from 1939 until 1970. He was a pioneer in interdisciplinary analysis of legal problems, and his scholarship on criminal law and jurisprudence was internationally recognized. Though he died in 1992, his work still is cited regularly today. Professor Hall's focus and approach has a deep place in our institution's history. The law school library, the Jerome Hall Law Library, is named in his honor. And our faculty continue to embrace Hall's work in their research and writing. His work was driven by the belief that understanding how law develops and its impact on society and culture is best understood through interdisciplinary analysis, and that we understand law better when we examine it through different lenses, situating law in its historic, its economic, political, ethical, social, and cultural contexts. It's also the belief that a true culture of democracy requires an informed citizenry that is comfortable talking about and thinking about the law. Law both reflects and defines basic social values. The whole lecture series brings influential and remarkable scholars to the Maurer School of Law each year. Recent lecturers have included Malcolm Feely from UC Berkeley, Rachel Moran from UCLA, Thomas Green from the University of Michigan, Sanford Levison from the University of Texas, June Corbone from the University of Minnesota Law School, and most recently, Janie Schwang from American University. Today, we're fortunate to welcome to this distinguished list a fabulous scholar, an award-winning teacher, and one of the nation's most well-regarded and longest-serving deans, Dean Kevin Johnson. Dean Johnson is someone who was particularly kind and supportive when I first joined academia, and it's terrific that he's taken time out of his extraordinarily busy schedule to be with us today. With that introduction to the lecture, I will now turn over the podium to Dean Christy Ochoa, who will formally introduce Dean Johnson this year's distinguished guest. Dean Ochoa, the floor is yours.
Thank you so much, Dean Parrish. It is an absolute delight to get to introduce Dean Kevin Johnson to all of you. In January 2014, the California Supreme Court Chief Justice Tani Cantil-Sacauye issued her decision in the case of Sergio Garcia, granting the State Bar of California's motion to allow Mr. Garcia to be issued a license to practice law in the state of California. That case is remarkable for a number of reasons. For Mr. Garcia, of course, it was the culmination of his efforts and his successes in law school and on the bar exam. It was also remarkable in California because, at least as far as I know, that was the first time that an undocumented immigrant from Mexico was granted a license to practice law in that state. It's notable today because of the many ways that it symbolizes who Kevin Johnson is as a person. Dean Johnson served as one of the lead attorneys for the State Bar of California in its petition to the California Supreme Court. Mr. Garcia, the subject of the case, was a recent graduate of UC Davis, where Kevin Johnson has been the dean and was his mentor. The recent statute that opened the path for undocumented immigrants in this way and was being interpreted by the Supreme Court that day was written by Luis Alejo, who was a former student of Dean and Professor Kevin Johnson. And finally, the Chief Justice who authored the opinion was also a UC Davis alum. The case screams about the importance, not just of excellent law schools in this country, but also of the invaluable role played by extraordinary people like Dean Johnson, who search for every available opportunity to employ their brilliance and their energy to effect real change on the issues that matter most to them. Dean Johnson is among the most effective, enduring, and most highly regarded leaders and scholars in this country. In addition to that, he's a committed mentor and a true friend. I want just to highlight quickly what I mean by all of that. Dean Johnson is a true leader. He's been the dean at the UC Davis School of Law since 2008, and he was the associate dean for academic affairs for 10 years before that. In addition to that, he serves as the director of the Chicano and Chicana Studies program at UC Davis. He served as a key advisor on immigration policy to the Obama campaign. He was on the Judicial Advisory Committee for Senator Barbara Boxer for 7 years, and he served on the board of directors for the Mexican American Legal Defense and Education Fund, and also served the bench and bar in California throughout his career. Within the Legal Academy, he is a member of the ALI and has served on a number of key leadership roles within the Association of American Law Schools. And those are just a few of his many, many leadership roles. Dean Johnson, lest we forget, is also a professor and a scholar. He's a tremendous scholar at that. He's written and been widely cited and recognized as one of the nation's leading voices on immigration, as well as a wide variety of issues connected to civil rights, race in the law, and diversity in education and within the legal profession. His voice is uniquely valuable for his adept ability to seamlessly blend critical race scholarship, doctrinal scholarship, and law and social theory as well. The world is better for his prolific work. He's written 9 books, and his articles and essays and book chapters fill literally 21 pages on his amazing CV. In addition to this, he is the founder and a constant contributor to the country's most important immigration law blog, and uses that platform to advance not just the important issues, but also the important contributions of his colleagues from around the world working on related issues. Dean Johnson is a tireless mentor. Just within this law school, 2/3 of the way across the country from Davis, his mentorship has affected, assisted, and guided the careers of many of my dearest friends on our faculty. I know this is true at nearly every law school in the country, which is truly impressive. His insights as a scholar and dean have touched many of our hearts and have helped us with many of our toughest decisions. And I know we feel deeply indebted to him for that mentorship. Kevin Johnson is also a devoted friend. For decades, he's been a true friend, for example, of my colleagues Luis Fuentes-Rower and Jay Krishnan. And I, as well as a number of my other colleagues, feel very fortunate to count him as our friends as well. I want to just give you a very quick anecdote and then turn the floor over to Kevin Johnson. On one of my first days here as a faculty member at IU, I was still feeling disoriented, pretty alone, and definitely like an imposter in my new office, when I received a thick envelope from Dean Kevin Johnson. Now, I knew of Kevin from his autobiography, which is titled, How Did You Get to Be a Mexican? A White Brown Man's Search for Identity, which had touched me years before that, because the book told so much of my brother's story, my father's story, and my own story as well. And I'll never forget that book. And here I was sitting in my office, in my brand new office, holding a letter from Kevin. That letter not only welcomed me, but it also provided me with a Rolodex of every Latinx professor in the country. I remember how the light was shining in my office that day because I felt warmed and welcomed and like I was in good company. And I know that I thanked him then, but that was nearly 20 years ago. So I just want to thank you again, Kevin. Through all of this, he has continued to teach on immigration, on the legal profession, and on a range of other courses. And as you're about to see, he is a renowned and fabulous teacher. We're so lucky to have you here with us today, Kevin. The floor is yours.
Thank you for that very kind introduction. I didn't write that. Made me blush, and I very much appreciate the kind sentiment. I'm sorry if I fail to live up to any of your statements about me, Professor Ochoa. But I'm truly honored to be here to deliver the Jerome Hall Lecture at Indiana Moore School of Law. When I say here, I know I'm saying here virtually. And I truly wish that I could be with you in person. And I look forward to the pandemic being over and some degree of normalcy returning to all of us. I've read some about Professor Hall, who sounds like an incredible scholar in many different dimensions. And it's lectures like this that promote intellectual discourse at a law school and a legacy of an important scholar and member of the law school community. So I think that lectures like this are incredible opportunities for everybody to reflect on the past and think about the future. I want to thank all those who involved in putting this talk together, Dean Parrish, Professor Ochoa, Professor Luis Fuentes-Rower, for getting me out here virtually. I want to thank Chelsea Browning for all the hard work and keeping me on track, because I can sometimes meander, and I appreciate her help. And I want to thank my assistant Starla Bennett, who will be in charge of PowerPoints. I'm entering the later stages of the 20th century by having my first PowerPoint presentation today, and Starla is helping me out. I feel incredibly thankful to be giving this lecture, and I have very good feelings about the Indiana Law School. In fact, the Indiana Law Journal published one of my most cited articles that actually relates to part of what I'm going to talk about today. And I was always impressed with their support in an area that helped me immensely. Now, I'm going to talk today about the harsh treatment of Chinese immigrants in the late 1800s. And I'm not just going to talk about history. I'm going to talk about how that period in our history has influenced the racism that's baked into the modern US immigration laws. And sadly, anti-Asian hatred is not part of our history, but is part of our present. The disturbing events in Atlanta and the year of violence against Asian Americans drive that point home. And actually, it's incredible to me, but just days before Atlanta, the US News and World Report proposed a diversity ranking that would treat Asians as white for purposes of evaluating diversity of a law school. Even US News understood that that couldn't stand and changed the whole ranking system to include Asian Americans as people of color, and then ultimately discarded the system that they devised because it would have classified Barack Obama and Kamala Harris as white, mixed race people as being white. In some ways, Atlanta changed all of that, and I think reminded us, and this is incredibly important to all of American law. Atlanta reminded us that race is a political and social construction that can change over time, can endure over time, but it's something that we've created and we must address. But that's a topic for another day. My remarks today are going to focus on bringing racial justice to immigration law. And over the last year, in the midst of the pandemic, a series of police killings of African Americans have provoked demands for racial justice, demands that many people, myself included, believe were long overdue. And this last week, I imagine you're in the same boat I am, but watching the news reports on the George Floyd trial is deeply disturbing and unsettling as they show the video, the horrible video, the sickening video, again and again and again. Now, in her celebrated book, The New Jim Crow, Michelle Alexander demonstrates that although the Supreme Court years ago outlined de jure racial segregation, the criminal justice system permits systemic and legal discrimination against African Americans. And in her a revised edition of that book that was released just last year, she added Latinos to the mix as well as immigrants to the discussion of the criminal justice system being skewed. In response to the latest string of Black killings by police, protesters, sometimes rioters, took the streets in cities across the country. Armed political counter-protesters added to the turmoil. And matters worsened beyond belief when racist extremists literally stormed the US Capitol. Now, to this point, immigration hasn't been central to that discussion, but immigration historically has been a place of racial discrimination in the United States. Today's immigration laws on their face appear racially neutral and colorblind, but they have unmistakable adverse impacts on people of color from the developing world. And we all know it. We all know who's being denied entry to the United States. We all know who's being deported from the United States. And at their most basic level, the laws as applied limit the immigration of people of color to and facilitate the removal from the United States. In recent years, there's been some pressure from immigrants and their supporters to take, and they've taken to the streets. They've called to abolish ICE and demand no less than just treatment of non-citizens of color. This is new and different in US history. In the past, and it wasn't that long ago, when President Bush referred to undocumented immigrants as people living in the shadows. Now we have undocumented immigrants who are willing to risk it all to protest what they view as unjust, unfair, and discriminatory laws. Now, in some ways, the call to abolish ICE is a demand for no less than justice for non-citizens of color. And the call to abolish ICE very much resembles the calls for the abolition of the police. Now, this new immigrant rights activism generated a powerful, much more powerful than I would have guessed, counter response led by none other than President Donald J. Trump. He appealed to a base of supporters demanding severe restrictions on immigration and the mass expulsion of immigrants of color. That same base that supported immigration restrictions also opposes the Black Lives Matter movement. I would posit that white supremacy is at the core of both movements. Now, I know this is a strong claim, but I think it's more than justified. Frankly, I'm shocked that the kinds of things that were said about immigrants could be said by a president of the United States. President Trump, for example, portrayed Muslims as presumed terrorists who should be subject to extreme vetting before entering the country, if not banned from entering the country. Can you put up slide 1, Starla? We don't want to put the PowerPoint slides up at the beginning, or otherwise we'd have a picture of President Trump up for the whole presentation, and Starla was worried about that. But in announcing his presidential campaign, this is what then candidate Trump had to say about Mexican immigrants. They're bringing drugs, they're bringing crime, they're rapists. Some, I assume, are good people. Those words have been repeated a lot, but I think they're worth focusing on and thinking about what President Trump thought about Mexican immigrants. As president, he later said that we should be, as a nation, leery of admitting people and allowing people to stay from what he called S-hole countries, such as El Salvador, Haiti, and most of the countries in Africa. He was specific. He also said that more immigrants should be coming from Norway. And he mentioned Norway by name. And what followed in the Trump administration was a staggering array of immigration initiatives with racially disparate impacts that literally was hard for many immigration law professors to keep up with. They were not limited to things like the Muslim ban, the family separation policy, the return to Mexico policy, and many more. Now, because the immigration laws determine who may come to the country and who may remain in the country, they historically have served as a very efficient tool for racial discrimination. They were during the period of Chinese exclusion that I'll talk about shortly, and they are today. You see that the Trump administration's separation of families and various asylum policies fell almost exclusively on Mexicans and Central Americans. And they typify how race continues to be central to contemporary US immigration policies and their enforcement. Unlike yesterday's nativists, most policymakers, with President Trump a notable exception, but most policymakers deny that their policies are racially motivated. They say things like, that's the law, what part of illegal don't you understand? Now, the immigrants' rights activist demands and the Black Lives Matter movement both demand an end to systemic racialized law enforcement. Now, in helping to analyze that push, I focus today on the discriminatory foundations of the US immigration laws and the continuing lack of meaningful judicial review of the laws that shield invidious discrimination from judicial review. Don't get me wrong, immigration activism is essential for true transformative immigration reform, but more is needed. And this is my central point. I think that a full transformation of immigration law to remove racism root and branch, or at least try to, can only be accomplished if the Supreme Court requires meaningful constitutional review of the immigration laws. and allows the courts to serve as a true check on unbridled racial animus. Constitutional limits on the immigration laws are necessary. Now, as I'll spell out, they don't exist today. Now, I want to talk a little bit about a period that many people think is part of our ancient history, but really is a part of our modern immigration system, the Chinese exclusion period in the late 1800s. Can you put up slide 2, Starla? Please. Thanks. Now, many people think of California as this left-wing place where immigrants have it easy today. I'm not sure I accept that, but I think I do know, for example, that California was a hotbed of anti-Chinese sentiment in the late 1800s, and was the home of what was known as the Working Man's Party, a populist labor movement, which had a slogan, "The Chinese must go." You see that on this New York State Archive banner that was displayed in California at the time. But there was widespread anti-Chinese sentiment in the state in the late 1800s. In California, Chinese were literally run out of town through economic pressure and vigilante terror. As was the case of lynching of African Americans, juries didn't hold white perpetrators accountable for their crimes against Chinese. And I can give you many examples, but one of them I kind of ran into in some of my research and in some of my my spare time in a mountain town called Truckee, which is about an hour and a half from here, and is near a place called Donner Summit, where the Donner Party many met their tragic end in a horrible winter as they tried to make their way to the West Coast. But in Truckee, there's a group of white men who are members of a group called the Caucasian League. The Caucasian League had a meeting where they appointed a committee to give the, quote, Chinamen a scare, end of quote. They went to a group of cabins where Chinese workers lived on what is known as Trout Creek, sort of not very far from a lake known as Donner Lake, and not very far from, if you know any of the ski places up in Sierra Nevadas, in that area, Squaw Valley, and also North Star, and others as well. But the Caucasian League members went to the cabins. They lit the cabins on fire. The workers fled. The Caucasian League members shot them, including killing one called named Ping. And there's a trial. White defendants were acquitted. It took the jury 9 minutes to acquit them all, even though there was testimony that made it clear what had happened. Jury nullification, which protected white murderers, literally in the South, also protected white murderers in the Sierra Nevadas. Now, with this vigilante terror and this anti-Chinese sentiment, grew national anti-Chinese activism. And after a number of years, it was successful, and Congress passed the first comprehensive national immigration laws, which were known officially as the Chinese exclusion laws. Can you put up slides 3, Starla? Now, these laws basically began a process of excluding all Asians from the nation. Started off with Chinese workers and then expanded their way. And one of the reasons there was an expansion in the discriminatory laws is that the Supreme Court upheld these laws in a way that made it clear that the courts were not going to interfere with the judgment of Congress when it comes to immigration. In what is known officially as the Chinese exclusion case, Supreme Court upheld the first federal immigration law, the Chinese Exclusion Act of 1882, which outlawed immigration of workers from China to the United States. And the Supreme Court, in uphholding the law, gave birth to what is known as the plenary power doctrine. That is, that the Congress and the executive branch have plenary power over immigration, and that there's no room for constitutional review. And in this famous quote, the Supreme Court makes it clear that there's no room for any constitutional review. If Congress considers the presence of foreigners of a different race in this country who will not assimilate with us to be dangerous to its peace and security, its determination is conclusive upon the judiciary. It doesn't say presumptively conclusive or possibly conclusive or likely conclusive. It says the determination is conclusive. Now, this ruling became the foundation for case after case, completely denying any judicial review of the legislative and executive branch's immigration decisions. To this day, the Chinese exclusion case has not been overruled. It's the law of the land. So there's no way of engaging or convincing a court to engage in the constitutional review of the immigration laws, which define who to exclude, who to admit, and who to deport from the United States. Discrimination is required for the law to accomplish its mission. But the Chinese exclusion case allowed Congress to discriminate without fear of judicial interference. We have full-blown constitutional immunity for immigration laws that allows Congress to act on its worst instincts, which is precisely what has happened. One of my philosopher friends says that this is known as in philosophy as the state of nature. There are no rules. Nature runs its course. And when it comes to the immigration laws, the state of nature dominates. Now, unsurprisingly, the Chinese exclusion laws couldn't be effectively resisted by the Chinese. They were unable to vote. They lacked representation in government. Politics wasn't going to help them out. Politics running its course generally meant that the Chinese were punished with impunity. Legal challenges had very limited impact, moderating the laws and their enforcement. Racism was allowed to go unchecked. And now if you look at the town of Truckee, which I talked about a few minutes ago, a town that once had 25% Asian Americans in its population, now has less than 1% of its population being Asian American. And there's virtually no semblance of any of the rich Chinese history that existed in the town of Truckee. Now, similar to Jim Crow's subordination of African Americans, the Chinese exclusion case's failures to subject the immigration laws to constitutional review made discrimination against the Chinese entirely lawful, just like Jim Crow was lawful. But Jim Crow was overruled by Brown versus Board of Education. Chinese exclusion case has never been overruled. By decreeing that the immigration laws were immune from constitutional review, the Supreme Court signaled Congress that it could pass laws that punish various unpopular groups of immigrants throughout the 20th century. Later laws passed by Congress restricted immigration, not just from China, but from all of Asia. Later immigration laws passed by Congress limited and restricted immigration from Southern and Eastern Europe with what some members of Congress said at the time included inferior races of people, including many Jewish persons, many Italians, and many others who some Americans, including those in Congress, didn't want to come to this country. Latinx and Muslim non-citizens are the contemporary disfavored groups, with Asians often unpopular as well in our immigration laws. And over time, the immigration laws have labeled for discrimination and punishment other groups. The poor, you probably heard about the revised public charge exclusion supported by the Trump administration, Well, our immigration laws allow for poor people to be discriminated against and denied entry to the United States. Our immigration laws once allowed discrimination against LGBTQ people from the United States, HIV positive people, persons with disabilities and the infirm, political minorities, and others. The plenary power doctrine has allowed all of those discriminations or forms of discrimination to stand. Now, over time, the Supreme Court has grudgingly allowed some limited review of the immigration laws and policies. But the default rule is the rule of the Chinese exclusion case and its progeny, that there's no constitutional review. Courts often treat any constitutional review, even very limited constitutional review, as kind of a gift to immigrants that deviates from the norms. You can look at a number of recent cases. I'll look at the travel ban case in just a minute. But there's another case that sort of below the radar of most people, but it was a 2020 decision written by Justice Alito that upheld the summary deportation of an asylum seeker from Sri Lanka who was apprehended in the United States. It was close to the border, but he was in the United States. But he was removed without a due process, without the right to counsel, without a hearing, and with decision fully made by immigration enforcement officers. And the court said basically that the plenary power precedent made it clear that this applicant had no due process rights that we needed to honor. Even though the Supreme Court famously ended de jure racial segregation against African Americans in 1954, it reinforced with vigor the plenary power doctrine. Justice Felix Frankfurter put it this way in 1952, in language that has never been overruled. Whether immigration laws have been crude and cruel, whether they may have reflected xenophobia in general, or anti-Semitism or anti-Catholicism, responsibility belongs to Congress. Now, this is the case despite the fact that of the incredible weighty individual rights at stake when a non-citizen seeks to enter the country or faces removal from the country. The Supreme Court has said that removal from the United States risks possibly, quote, the loss of all that makes life worth living. Loss of family, friends, community, jobs, and entire lives. There's a recent book by Beth Caldwell called Deported Americans, where she conducted hundreds of interviews of people who were long-term residents of the United States who had been deported to Mexico, most of them for relatively minor crimes, and gets from them words from their mouth about how their lives were turned upside down. Even though the plenary power doctrine dominates and obscures the rights of immigrants, when the rights of citizens are at stake, whether it's gun rights or free speech rights, modern constitutional law generally requires very careful judicial review of the law. Now, in terms of immigration, politics, not the courts, remove some of the most blatant racism for US immigration law. It's politics and a civil rights movement and the stark inconsistency of racist immigration laws with modern sensibilities that brought us the passage of the Immigration Act of 1965, which finally did away with the last remnants of the Chinese exclusion laws. But still, the Chinese exclusion case remain, and they affect judicial review of important immigration decisions. The Supreme Court in Trump versus Hawaii relied on plenary power precedent and applied a very narrow standard of review to uphold President Trump's proclamation barring the admission of non-citizens into the United States, most of them from a group of predominantly Muslim nations. The court explained that it needed only a, quote, facially legitimate and bona fide reason for the policy. Toothless rationality review carried the day, and the Supreme Court, in a 5-4 decision, upheld the travel ban. The court, in applying the plenary power doctrine, largely discounted Donald Trump's numerous anti-Muslim statements and accepted the national security justification for the travel ban. Justice Sotomayor dissented. She found, quote, a reasonable observer would conclude that the travel ban was driven primarily by anti-Muslim animus, not national security. Now, in some ways, the plenary power doctrine remains, but in some cases, the court does apply more generous constitutional review. Meaningful constitutional review is a powerful intellectual force in our jurisprudence today. But in immigration law, the tradition of no judicial review of the immigration law and policies also is a powerful tradition, with the Chinese exclusion case as its anchor. Another recent example that tells you just how intention the Supreme Court precedent is the DACA case. The Department of Homeland Security versus Regents at University of California. In that case, the court was reviewing the Trump administration's rescission of the Deferred Action for Childhood Arrivals policy, the DACA policy, which provided limited relief to non-citizens brought to the United States as children. Now, in that case, the Supreme Court held that the rescission was arbitrary and capricious and violated the Administrative Procedure Act. So far, so good. But the court also found that an equal protection claim had not been alleged, plausibly established by the plaintiffs in that case. That the racial animus necessary to prove an equal protection violation had not been sufficiently alleged. That was the case, even though the rescission of DACA would have affected DACA recipients, 90% of whom were Latino. They would have been directly affected by the rescission. And we also have a president who repeatedly vilified Latinx immigrants. Now, meaningful constitutional review of immigration decisions promises to better protect citizens, non-citizens. But besides creating a check on discrimination and a check on excesses by Congress and the executive branch, meaningful constitutional review would facilitate a dialogue between the courts, the Congress, and the executive branch on the rights of immigrants. We haven't seen much of a dialogue about the rights of immigrants between those branches of government in recent years. The benefit of a productive dialogue between the three branches of government can be seen in the evolution of the travel ban case. Lower courts invalidated the first two versions of the travel ban, a more narrow version, and I think an improved version, even though I might say it still should have been struck down, but an improved version nonetheless was upheld by the Supreme Court. The first version was incoherent. The third version was coherent, even though I may have disagreed with it and think it should be struck down. It was an improved and narrower version. Nor is constitutional review of the immigration laws impractical or without precedent. At various times, the Supreme Court has reviewed the constitutionality of state laws discriminating against non-citizens. There's a case from the 70s, Graham versus Richardson, where the Supreme Court applied strict scrutiny review to strike down a state law that barred public benefit receipt by lawful permanent residents. At the same time, the Supreme Court at other times has held that citizenship qualifications for public officers, including law enforcement officers, are constitutional. So some kind of constitutional review doesn't mean all immigration laws by the states get struck down. And also at times, the Supreme Court has struck down provisions of the US immigration laws. Very few times, but in some times. In a 2018 case, the court struck down a criminal removal ground is unconstitutionally vague. It applied standard void for vagueness doctrine in cases. Similarly, in another case, Sessions versus Morales-Santana, the court invalidated on equal protection grounds a gender distinction disfavoring men in giving citizenship to their children. And it was a decision written by the late Justice Ruth Bader Ginsburg. These decisions didn't mention the plenary power doctrine. They engaged in ordinary constitutional review of the provisions of the immigration laws. And they show that the world would not end with some kind of constitutional review that serves as a check on Congress. If the court were to dismantle the plenary power doctrine and review the constitutionality of federal immigration laws and policies, there would be workable and meaningful modes of review available. Now, the prospects for change, and I'll try to wrap it up shortly, aren't, I have to admit, primarily going to occur through the courts. Political activism and immigration reform will have more of an impact in the long run than the courts. And we see immigrants engage in political protests. We see immigrants having impacts on what state and local governments do when it comes to immigration. I think immigrant activism led to the DACA policy, and resistance to the rescission brought that to the national attention. And I think that we are in a place today where political action can have more of an impact than it could in the period of Chinese exclusion. With changing demographics, changing immigration streams, there are more possibilities for political action than in the past. And political action is much more likely to secure lasting change in the immigration laws than short-term change. But at the same time, activism cannot bring all the improvements and all the racial justice that's necessary to immigration law. Only through raising the Chinese exclusion case will it be possible to truly bring racial justice to immigration law. Meaningful constitutional review would discipline Congress and the executive branch in their treatment of immigrants and would limit the racial excesses that we've seen in recent years and in US history. Constitutional review would narrow the range of political possibilities for compromise, and in that way, promote reform in reasonable and thoughtful ways. Constitutional review would allow for the review of discriminatory and often extreme laws and enforcement measures that affect large groups of immigrants, including those with glaringly disparate racial impacts. Without constitutional constraints, the nation can expect repeated episodes of anti-immigrant sentiment fueled by racial animus, whether it's the kind we saw during the period of Chinese exclusion or the kind that we've seen in recent years, with the Trump presidency simply marking the most recent and extreme case. In the end, overruling the Chinese exclusion case and revolutionizing the constitutional review of immigration law is necessary to ending Jim Crow in the modern immigration laws. I'm sorry I went on so long, but thank you for your attention, and thank you for thinking about these issues. And to me, immigration is one of the important civil rights issues of our century. And if anybody tells you there's easy answers to all these questions, I don't think they're telling you the truth, because I find them incredibly complex. But take care, and thanks for having me. And I look forward to questions and answers.
Dean Johnson, thank you. This was tremendous, as we hoped and knew it would be when we thought to invite you a year ago. Christy did a tremendous job, in fact, better than I would have. I just want to be clear. Introducing you, I just want to tell a very quick story. I was about to teach immigration law, a seminar a couple of years ago, maybe 3-4 years ago. And I started looking for articles to cite for my students. So I do a search on admission, and there you are. And sealing the border, and there you are. By the end, I literally, LOL doesn't really mean anything. I literally laughed out loud by the 10th search when you came up at the top in writing in the space I was looking for, which it speaks to you as a scholar, not to mention you as a dean, as a person, and as Christy suggested, all of that. So thank you. I'm deeply honored. We did flip a coin and she won. So I ended up doing the Q&A. So here we are. So I'm gonna, the audience, please note, if you have questions for Dean Johnson, please put them, there's a little box at the bottom somewhere. And I will go to your questions in a second. I just want to ask the first question. As I think about your talk and I think about the plenary powers doctrine, I think about the Chinese exclusion cases, I think about when they came about in the 1880s, 1890s, as you pointed out, Dean Johnson, they came about at a time when the court wasn't, I think it's fair to say, at its best. This is Chinese exclusion. This is Plessy versus Ferguson. The Fuller Court is not one we think back upon as fondly as other courts. This is a time, which is something I've been thinking about a lot, of the insular cases in 1901, which, if you don't know them, they're the ones that opened the door for colonialism in the United States. And what we see today about Puerto Rico, it dates back to that moment, 1901. You pointed out that the court overruled the Jim Crow era and Plessy v. Ferguson in 54. This is Brown. And yet most other cases in the spaces I think about, and the race cases, remain with us. The one you mentioned, Che Champagne, I think Downs versus Bidwell. Do you have a, and I think I have a story, but it's not my talk. So I'm going to ask you, do you have a story as to why there's selective remnants of that, of a time that we look back upon in ways that shame many of us, if not, I suspect all of us? As you're calling for the court to step in, I mean, this should have ended, right? Even and I say even with trepidation, even Korematsu, now we look back, right? Justice Roberts, Chief Justice Roberts came and said a few years ago, though not presented to us in this case, we must say that case has been effectively overruled by history. And yet all these other pieces remain. Do you have a story? Why?
I mean, I think that the good news is the nation has begun and it continues to engage in an interrogation and the reckoning, really, with the legacy of slavery, Jim Crow, and the treatment, horrible treatment of African Americans in our society. I do not think the same reckoning has taken place when it comes to a number of other groups, including how we've treated our territories, or how we treat immigrants, or how we treat indigenous peoples. I think it's funny where you see plenary power doctrines and absolute immunity from constitutional review. It's always by coincidence, I guess, falling on people of color. Who, the Native Americans are subject to plenary power. People living on the territories are subject to plenary power. Immigrants are subject to plenary power. I do think that there's a lot of work to be done to continue to challenge these pillars that are accepted as conventional wisdom. The Chinese exclusion case. I mean, if you think about the name, it's embarrassing. It's embarrassing that we're talking about these laws that still have an impact, and that some justices, including Justice Scalia, would still cite the case. I think that it's a work in progress. It's on all of us as a country. And the truth is, there probably are more cases that come up involving the legacy of racism in American social life than in the rights of Indian, Native Americans or immigrants or the rest. But I think we have to continue to push this. I also have to say that for a time in immigration law, many scholars viewed immigration law as not about race at all, as really about sort of colorblind rules, and that everything was good, even though some truly crazy things exist in the immigration laws. I'll tell you one of the it's hard for me to come up with a rationale for, but the Supreme Court in the 70s upheld immigration stops based on a number of factors, including Mexican appearance. That can be one legitimate factor. We're not talking about stopping people for individualized suspicion, but one factor, and nobody talked about, how Mexican appearance could be a problematic thing to consider. I don't know what it is. I don't know if you could, you can talk about stereotypical Mexican appearance and things like that. But the Supreme Court, and I think a fair number of Americans don't think that race is involved. And I think educating them about the centrality of race is very important. And for me, and one of the reasons I've been thinking about the Chinese exclusion case so much is now we have colorblind and race neutral systems that make it look like everything's hunky-dory. Even though, this is, I won't go into details why this is the case. If you're for some visa categories, if you're from Iceland, you can get one tomorrow. If you're from Mexico, you'll have to wait 20 years to get one. Just the way the system works.
Thank you. Let me ask a question from the audience. How do you see gender playing a part of the racialization of and exclusion of certain immigrants? For example, I'm thinking of the Page Act of 1875 and recent shifts in asylum policy that makes it more difficult for those who have experienced gender-based violence to make a valid claim on the basis of that violence.
Now that's a good set of questions, and I think that many people don't realize how much our immigration laws discriminate against women, particularly women of color. The Page Act focused on Chinese women as presumptive prostitutes and basically barred their entry to the United States. But there's so much, some incredible stuff that it's been written about, but a lot of people don't know about. Like if you're a citizen woman and married a non-citizen, married an immigrant, you lost your citizenship and you assumed the citizenship of your husband. And if your husband wasn't eligible to ever become a US citizen because he was Chinese, for example, then you could never become a US citizen, even though you once were a US citizen. But you could be stripped of your citizenship if you married an immigrant. Many people don't realize how large the woman migrant stream has been throughout history, including today. And some of the most heartbreaking asylum cases are some of those based on gender-based persecution that the Trump administration sort of clamped down on. We'll see what happens in the Biden administration. The Obama administration actually, I think, evolved in a better direction. But I think there's a gender dynamic to immigration that historically women have been poorly treated, and in modern times as well. It's not as archaic as it once was, but the treatment of women who fled intimate violence, women who fled gang violence, and I spent some time along the border a few years ago, and it had a profound impact on me. And I talked to a number of women who were making the crossing by themselves, and the fear that they had of crossing the border by themselves, what might happen on that way, was it was very disturbing to me. In this town square, a place called Altad, right in the Sonoran Desert, right across from Tucson. Among the many things you could buy before you made your journey was a day after pill in the event that you were raped and might get pregnant. And it just, I still can't forget some of those scenes, I have to say. And women are the most vulnerable in those crossings.
We're pushing against our time. I imagine we have time for maybe one more question. So Dean, here's of course, and I'm going to give you a big question from the audience. In fact, quite big. So here goes. Question asks, this might be to Ethereal, but I am curious how exactly we overcome these racial animosities. For example, Sicilians are no longer really subject to the animosity we saw when we immigrated here in the late 1800s. We have the benefits, especially those of us who are mixed with Neapolitans and others, whiter Italians, of passing as simply white. But how did we get to this point?
That's a complicated question. I could write a book about that. One of the things that's interesting is that some groups, for some reasons, find it much more easy, or I don't want to say easy, but much more possible to assimilate than other groups, in part because of what are perceived physical differences. I think, for example, the claim is often made that immigrants like Latinos, Asians, fail to assimilate and should keep them out of the country. Actually, that's in the quote from the Chinese exclusion case, that people won't assimilate. I think that for some groups, assimilation is much easier said than done. How we get beyond all that, I'm dealing with much more mundane kinds of questions. Your question is an important one, but I wish I could convince people to have rational discussions about immigration. I mean, to talk about what we really should do as opposed to dehumanizing people. I mean, actually, I think we're at the first step with some people that, and I think the whole debate, and it's become more of a debate, and I wrote about it in the 90s, but now they're talking about not using the word alien in referring to non-citizens. And I argue, and I believe that the word alien and illegal alien are code for people of color and for non-people that we can treat with impunity, which is the kinds of things we saw during the Trump administration. I think language is important, and I think that we should be careful, and we should realize at a most fundamental level that our laws about admission and deportation affect people in their lives, their families, their friends, and we should take that most seriously.
And with that, Dean Johnson, that was thoughtful, that was interesting, thought-provoking, and I thank you from the bottom of my heart. I thank you for coming, air quotes, coming to the law school. Please know that you will have to, air quotes, come back soon, because this does not count. And with that, thank you for your time, for your thoughts, for being our speaker today.
It was an honor, and I'll surprise you. I'll just tap you on the shoulder and I'll be right there.
And with that, Dean Parrish, do you take it away, or do I?
No, I think you can, Luis, but in any case, I think the audience will join me in thanking Dean Johnson for a fabulous lecture. Dean Ochoa and Professor Fuentes-Rohr, many thanks for the handling of the Q&A and the introduction. This concludes the 2021 Jerome Hall Law Lecture. Thanks for everybody for joining us. Take care.
Thank you.